Hello, Class 9. Class Notes of the Vision IAS Polity. Citizenship acquisition process continued. Citizenship by the naturalization. The central government may, on as application of the great certification of the naturalization, any person not illegal migrant if he is the passes the following qualification. A. That is not a citizen of any country where the citizens of India are prevented from the becoming the citizen of the country by the naturalization. B. If a citizen of any country, he undertakes the renounce the citizenship of that the country in the event of this application began the accepted in India. C. If he is the either resided India or the been the receive a government in India partly to one or partly to the another over the period of the 12 month presiding of the date of the application. A. He must be a good character. E. He must have the adequate knowledge of the language specified in the 8th schedule of the Constitution. If once he is a given citizenship, he will be eligible to the reside India is to serve in the government of India or in the any international organization or company set by the any citizens. G. The government can be remove all or any these conditions if the government feels that the person has the rendered the distinguishing services to the science, philosophy, art, literature, world peace, or the human progress by the incorporation of a territory. If any foreign territory becomes a part of the India, the government specifies the person within the particularly territory who can become the citizen of the country. For example, when the Puducherry became the part of India, people were granted Indian citizenship. Losses of citizenship by the renunciation. Any citizens of India of the full aged capacity can make the declaration renouncing his the Indian citizenship. Once his the declaration is registered, then that the person has ceased to be the citizen of India. If this the declaration is made during the time of war, its registration will be withhold any the central government till the end of the war. By termination, when the Indian citizen voluntarily acquires citizenship of the another country, his Indian citizenship automatically is terminated. By deprivation, it is the compulsory termination of the Indian citizenship by the centrally government. A. If the citizens have obtained the citizenship by the fraud. B. The citizen has shown the disloyalty to the Constitution of India. C. The citizens has unlawfully traded or the communicated with the enemy during a war. D. The citizen has within the 5 years after the registration or naturalization been the imprisoned in any foreign country for 2 years. The citizen has been the ordinarily resident out of India for 7 years continuously. Overseas citizenship of India. In the September 2000, Government of India set up the committee to the engage constructively India, the citizen wherever the residing abroad. Citizenship Amendment Act 2003 made the provision for the acquisition of OCI, Overseas Citizenship of India, by the PIOs, persons of Indian origin of the 16th specified the countries other than Pakistan and Bangladesh. OCI is the not the dual citizenship as the Indian Constitution have been provision only for the single citizenship. In 2002, the PIOs card scheme was introduced, and later OCI card was introduced in 2005. In order to avoid the confusion and also the order to provide the more benefit, the governments decided to the merge the PIOs and the OCI's schemes. In 2005, the Citizenship Amendment Act was the passage and it introduced the OCI cardholder schemes. OCI card holders can be benefited in the form of the multiple entry of the life lodging visa for visiting India for any purposes. They enjoy the priority with NRIs with the respect to the all specified available to them all fields of the economic, finance and education. They can visit India without visa for lifelong fundamental rights and the philosophy explanation. Part 3, Article 12 to 35, Fundamental Rights. The rights, it is the privileges conferred on a person. Fundamental rights, the basic to our existence. We cannot live without these rights. We cannot lead the respectable, uh, dignified life without these rights. As human beings, when we take the birth as the free soul, then there is no restriction, and at the time of the death also no restriction, the right of life. Without the right of life there is no meaning of the existence. For any democratic government rules based governance, the rights of life is the central. All of us are born equal at the time of the birth. There was no caste, no religion, and that is why it is natural for the someone's that if nature is not the discriminate, then the society should also not discriminate. Nature does not the differentiate such as the pond or tree. That is why it the natural to have the rights against the discrimination. After the birth, we are the given artificial identity slash ascribed the status which causes all the problems in the society. If is a long journey from the being human to being human. After the birth, we forget that we are the human beings and we follow the artificial identity. Why the should the differentiate slash discriminate for the something which was the assigned to us after the birth? We need the follow only we nothing is the humanity slash human beings. Discrimination of the fundamental rights. Fundamental rights are the called the fundamental because they are the essential for basic human existence. They are the granted and the protected by the constitution. They are the most essential for the round development of the individuals. They are the incorporated in the part 3 of our constitution from articles 12 to the article 35. They are the derived from the constitution of the USA Bill of Rights. They are the granted to the all person without any discrimination. Fundamental rights can be the broadly divided into the following categories: A. Right to the equality, Article 12 to 18. B. Right to the freedom, Article 19 to 22. C. Right against exploitation, Article 23 to 24. D. Right to freedom of religion, Article 25 to 28. E. The natural and educational right, Article 29 to 30. F. Right to property, Article 31. If it was removed by the 44th Constitutional Amendment and was made and the ordinary legal rights. G. The right to the constitutional remedies, Article 32. And the features of the fundamental rights. Some of these fundamental rights are available only in the citizens, while the other are available to the foreigner also. The fundamental rights are not the absolute. It means the state can impose a reasonable restriction and the journey will be decided whether the restriction are the responsible or not. All these fundamental rights available against the arbitrary action of the state. Some of them are available against the private individual also. Some of these fundamental rights are negative in character. Example, they place the limitation on the authority of a state, whereas the some areas are the positive, they are confirmed or the certain privileges on the people. Fundamental rights are justiciable via violation of these fundamental rights can be challenged in the court of the laws. Fundamental rights are the acrosense. Example, they are not the permanent or rigid. Parliament can limit the scope of the fundamental rights must be done with the constitutional amendment. It should also be done without the affecting the basic structure of the constitution. Fundamental rights can the suspend during the operation of the national emergency except for the rights of the grantee under the article 20 and 21. Six rights grantee under the article 19 can be suspended only where the emergency imposes grounds of the war and external aggression. Fundamental rights can also be limited. Article 31A, 31B and 31C. Article 12 of the Indian Constitution. Article 12 defines the state regarding the fundamental rights of the citizens under under Part 3 of our constitutions. It includes the following: A. The Government of India can the Parliament of India. Example, the executive and the legislative organs of the union government. Parliament consists of the Lok Sabha, Rajya Sabha and the President, whereas the executive consists of the Council of Ministers headed by the Prime Ministers. The government of the legislature of the state as the executives of the legislative organs of the state government. It includes the state legislative assembly, legislative council and the council of the ministers headed by the chief minister. See all of the local authorities including municipalities, panchayats and districts, board improvement trust and so on. D. All the other authorities, example statutory and non-statutory authorities like the LIC and NGOs as well. Articles 12 defines the state in the much wider sense so that the action of this organization can be challenged in the court of the law as a violation of the fundamental rights. Judiciary is not included in the definition of the state under the Article 12 of the Constitution because it given the power to pronounce the judgment in the case of the violation of the fundamental rights. When the judiciary performs non-judicial function, it falls without any definition and they are state under the Article 12 of the Constitution. Private sector are a part of the state. Recently, the issue come up regarding the inclusion of the private sector in the definition of the state. After 1991, India adopted the liberalization, privatization and the globalization as a part of LPG. The government has opted the public-private partnership for the infrastructure development and industrialization. And it has raised the question regarding the inclusion of the private sector in the definition of state. But till now, there is no clarity regarding the status of the private sectors in the definition of state. Thank you. Thank you very much.